gonna backtrack. And you should've kept my name out your mouth. Ask me though how it all turned out. When you try to use my name for clout, keep on going, give me something you could.
Still trying to get the hang of that. Hello, everybody. How you doing this fine Thursday? As the title suggests, there have been more than 20 documents filed in the last 1 day since yesterday, April 16th, 2025 through today. Right now, sitting here right now, 4:18. We got started a little early here for obvious reasons. Reading some of your, yep, Squirrel is squirreling somewhere. Yes, it is. Okay, so today I thought we could try something a little different. We're going to be doing a PowerPoint. Yes, I did put together a PowerPoint presentation because it's like, I don't know, 20 filings. It's just the easiest. I don't know why. But anyway, here it is. I truly don't know why. It just felt like this was the easiest way to do it. Okay, so here's the PowerPoint presentation. Just because it's on a PowerPoint presentation does not mean it's, facts. This is just the best of my understanding and all that. Thank you, iCats. I just started having a really good hair days recently. I don't know what's going on with that. It's probably because I'm God's favorite. I'm really not sure, but thank you so much for that. This is not wand. This is nothing. This is just like products, and I dried it. It's just like that. Anyway, yeah. Amen. There you go. You know what I mean? So, anyway, okay, so moving right along, we're going to be doing the PowerPoint presentation. So this PowerPoint presentation and this live stream is going to cover Diddy criminal court docket 229 all the way through 252. Okay, so that's more than 20. Okay. Thanks so much, Holly, for the $2 super sticker. Thanks so much, Cleopatra, for the compliment my background. Yes, I've been working on it. Shout out to my friend Pamela. I don't know if she's going to be here in the chat or if she is or whatever, but she's been helping me so much with the background. And thank you, Holly, for that $2 super chat. Okay, so moving to the next slide. Okay, so as you can see, team, the Diddy docket is quite a bit out of control. I don't know if you can actually see that. Actually, hold on. It doesn't matter. It's just illustrative. It's illustrative in any event. Okay. Moving along. Okay. Excuse me. So we're going to start at 229. This is Diddy's opposition to the Warner Brothers motion to quash. Now, Warner Brothers Discovery did make a documentary called The Fall of Diddy. And it wasn't them specifically. It was their subsidiary who did it. It was on Max, HBO Max, I believe. So Diddy opposes the motion to quash. Oh yeah. Okay. So it says arguments on next slide. Okay. It's 21 pages long. This was filed yesterday. Docket 229. Okay. So as you can see, 21 pages long. Yeah, no, the background is real. The background is real. It's like real. It's real. It's real. It's my mothership. Okay. So table of contents is what we're going to use to go through this. This is literally our first document. Okay, so we're going to be flying through. I'm not going to be doing too much nitpicking. This is just to get you up to date, up to speed, because guess what tomorrow is? Tomorrow there is another pretrial hearing. Okay, and there was just one Monday, earlier this week, Monday. Okay, so this was filed yesterday, docket 229. This is filed by Diddy. Now, Warner Brothers Discovery, they make this Fall of Diddy documentary, and then they interview some people in it. Some of the people they interview in it are going to be They are expected to be government witnesses, and they have been identified as individual A and individual B for the purposes of Warner Brothers' motion to quash. Diddy now is responding to Warner Brothers' motion to quash, is saying no, opposing it. He's arguing there's reasons why Warner Brothers has to turn over this material to him. Warner Brothers had argued, I'm saying Warner Brothers, but it's like HBO Max, whoever made that Fall of Diddy. Okay, not to be confused with Diddy Do It, not to be confused with Is Diddy a Murderer? You know, I mean, this is the Fall of Diddy that streamed on HBO Max. Might have been ID. But the parent company is Warner Brothers, and that's who owns the materials that are at issue. So as you can see at the top, the evidence at issue here are the interviews, the outtakes, and the behind the scenes with the two witnesses. That's interview, what does it say? Individual A and individual B. Okay. So Warner Brothers, that parent company, they had argued we do not have to turn it over for two reasons. Number one reason is Diddy can't even tell us why he wants it. This is just a broad fishing expedition. Number two, we are protected, us over here. We're protected from having to turn over that interview, those outtakes, those behind the scenes footage, by the fair reporter's privilege, or the fair reporter, the qualified reporter's privilege. Now, a lot of people were going up and down and all around over the fact that originally this subpoena had contained something about diaries, notes, diary entries, but Diddy is no longer asking for that. Okay, so he's not trying to get the diaries, he's not trying to get the journals, he's not trying to get the notes, he's not trying to get the payment proof of any financial transactions between Warner Brothers subsidiary and the individuals A and B. The only thing he wants is the outtakes and the interview footage. Thank you so much, Rabbit. Oh my God, shout out to you for that $4.99 super chat. Thank you so much. Y'all, Rabbit has been working over there down that rabbit hole. It is popping over there if you want to go check out. She's covering all kind of stuff. Thank you for that $4.99 super chat and for supporting the channel, Rabbit. So Diddy has responded to those defenses and the motions to quash, and Diddy has said no, they cannot hide behind the fair reporter privilege, the qualified reporter privilege, and the reason they can't do that is because this is a matter of exactly what these people are talking about. They're going to be testifying against me, and they were making the story about me. They knew that, it was an ongoing case when they made it, et cetera, but basically, no, the qualified reporter privilege does not count. And Diddy also says that this is not an overly broad fishing expedition. They're going to be testifying on exactly the same things as, like I just said, as they are expected to testify at trial. Now, Diddy's lawyers and Diddy say that, hold on, I have to hide someone from my channel. Goodbye. Anyway. Diddy's lawyers did argue and say that while the newspaper, while Warner Brothers is not protected by this privilege, even if they were or whatever, there's a whole nother reason why Diddy argues the court should compel Warner Brothers to turn over this footage to Diddy. Let me see what he said. He said, not only is it not a overly broad fishing expedition, he says that he's already found, or Diddy's lawyers say they already have found inconsistencies in these individuals' statements about the alleged events. Diddy has, his lawyers have said in court that the interview footage outtakes are likely to contain even more inconsistencies, and it would be basically like depriving Diddy of justice, he says. It would just basically be like not even a fair trial unless these interview outtakes were in there. Okay, so I'll leave it up to y'all whether you buy that argument or not. But anyway, that's what that document is about. So moving to the next slide, we have a document number 230, and this is Diddy's lawyer's declaration in support of that thing that we just looked at. Now, it is about to get very confusing. There's going to be a lot of different evidence. There's going to be a lot of stuff flying around. Okay, y'all just buckle up. I do have an Excel spreadsheet at the end. I'm going to try and encapsulate it all at the end. We are literally about to go through 20 documents. Okay. So just, it's probably going to be confusing, but I'm trying to make sure that by tomorrow's hearing, there's at least this in the docket, the public docket, not the real docket, of, an explanation, so that I make sure we're on top of things. Thank you so much, Savage, for the 1999 super chat, for all the things wings you do. Thank you so much for that 1999. That is very generous. Thank you. I appreciate that. Thank the mothership you made this PowerPoint. Y'all have not made a PowerPoint. I mean, I have kind of dabbled here and there, but I don't know why I was like, I have to make a PowerPoint. I don't know why. Okay, so this is just a declaration that Diddy's lawyers filed in support of his thing previous, what we just looked at, 229, which was Diddy's Diddy's opposition to Warner Brothers' motion to quash Diddy's subpoena. Diddy wants the interview outtakes. Okay, so this is a 230 is a declaration in support of that by Diddy's lawyer, Anna Estevao. Girl, Rabbit in the chat. I'm gonna need a pronunciation guide. Rabbit always can pronounce these names so pretty. Okay. So the next document number 231. This is the third one we're gonna be looking at. Was filed yesterday. This is a document. This is a letter to the judge from Diddy's lawyer, Mark Agnifilo. This is about the alleged 3 screenshots. Okay, so if you were following along on Monday, whenever there was the arraignment hearing, a little surprise hearing on Monday, then you remember us talking about some WhatsApp screenshots, and a capital C and a lowercase c cooperating witness was brought up. Some people speculated that this so-called, quote, victim 4 could possibly be KK, the longtime assistant of Diddy. There was some mention of Combs Global. There was some mentions of email records, et cetera, et cetera. Now, Diddy, through his attorney, Mark Agnifilo, had apparently on that day, Friday, April 14th, apparently on that day, there had been some sealed letters filed. And those sealed letters became the topic of discussion in the hearing on Monday, April 14th. Okay, so they're filed on the 14th, and then the hearings on the 14th, they're all talking about the 14th. Diddy's side filed a letter, and also the government, the feds, filed a letter. Now, in these sealed letters, they're now open. The sealed letters have now been open to the public. And that's one of the ones that we're reading right now. Okay. So the government says Agnifilo, this is written by Agnifilo, as you can see by the title of the slide. Docket 231, Agnifilo writes a letter to the judge regarding victim 4 evidence. And these are those alleged WhatsApp screenshots. So he says that the government says they recently got 3 screenshots of a WhatsApp conversation, but Agnifilo says this is apparently just a very small selection of a, quote, much larger conversation, much longer conversation. Agnifilo says we may need the court's intervention. The government is making, he says, a, quote, conscious decision not to take possession of certain documents, and they're doing it on purpose. I know that y'all probably by now are familiar with the Brady rule of evidence. Brady is Brady versus Maryland, where the government has to turn over all of the exculpatory and inculpatory evidence, which has, material relation to the outcome of the trial. This is how the Rust trial got deleted or whatever. Like, this is how the Rust trial got declared a mistrial. Was the Brady violation with the government whenever they're charging a criminal defendant, a defendant in a criminal case, innocent until proven guilty, including Diddy. But when the government's charging a defendant, it is like constitutional case law precedent and, reaffirmed over and over that the government does have an obligation, a duty to turn over certain of evidence. And the evidence is anything that used to be just exculpatory, then it was inculpatory, anything that could help anything relevant, pretty much, the government has to turn over. And so Mark Agnifilo and Alexandra Shapiro and Diddy's legal team, they're arguing that the government is on purpose not getting a subpoena from this victim 4, this long-term employee who worked for Combs Global, apparently. This is the subject of a sealed letter. Now, while these letters are unsealed, they are not unredacted. So they are still kind of infested with these large black bars that are covering up a lot of what's going on, or some portion of what's going on. Thank you again for the $4.99 Super Chat Savage. Typos, for all the things you do, especially the PowerPoints. Thank you so much. This is like my first foray into the PowerPoint in a long time. Okay. So we're on document 231. If you're still joining, we're going to be going all the way up to document number 252 at least. That was the most recent one that had been filed the last time I looked. Right now it's 4:32 p.m. Eastern, but we'll see. I have it in my mind. I have it in my heart. I have it in my soul. We're going to get caught up by tomorrow's hearing. I do have some water here. Okay. Love a good PowerPoint. Y'all are funny. Okay, so may need the court's intervention. This is Diddy's lawyer saying we may need the court to intervene. The government is making the conscious decision, Diddy's lawyers are arguing, not to subpoena the WhatsApp conversation from whoever this, victim witness 4 is, this victim 4, alleged victim 4. This is, Mark Agnifilo seems to be implying, in my opinion, based on what I can see, he's kind of implying that this is like basically already just bad enough to violate Brady. Like they're going out of their way not to get the full context of the WhatsApp conversation. Not only that, but, there's this other rule that they seem to be violating. This has to do with the, quote, forced labor predicate in the second superseding indictment. And then that second superseding indictment, forced labor predicate, did follow through to the third superseding indictment. Diddy and his lawyers say that they are in an untenable position to defend only with discovery. To defend himself, Diddy's like, this is untenable. This is ridiculous. I'm in this position because I have to defend myself using only the limited and select discovery that the government wants to, or decides, he says, to take possession of. Or I can try to subpoena it like I did with Warner Brothers. But whenever I subpoenaed Warner Brothers, the government filed an opposition saying that Warner Brothers should not have to turn over the interview footage. So either the government should subpoena these things and then give it to me through their Brady obligations and their Rule 16 obligations, or they should stop interfering whenever I subpoena. So these are Diddy's arguments. I am not, no, Sheena, I did not see that. Sheena said, did I see he was accused of pew-pew with Justin? No, I did see somebody had a thumbnail about Justin Combs. That's all I saw. I don't know about a pew-pew or anything else. I've been reading 20, 50, 11 documents today. I don't know if y'all... No, it takes a long time to get through these. Okay. So what else is on here? Okay, so that's pretty much, I think, document number 231. No, we're going to continue to the next slide. I did notice this was kind of strange. There appears to be an issue here. Like Mark Agnifilo didn't sign this. It looks like he didn't sign it. There's no like S with the /. So I don't know if that matters. I don't know if that matters. I noticed that actually on a couple of the documents. If Mark Agnifilo is watching my videos, you might want to go fix those before the other side calls y'all out. Or maybe it's okay. I don't know. I don't file documents in federal court, so I don't know. Anyway, okay. So next document we're going to look at is the government, the feds, they are responding. They're responding to what? To Diddy had asked for a very large number of things. It feels like, try to keep track of at this point. One of the things he's asked for is 2-week adjournment, like time extension. But then he decided it's not 2-week adjournment. No, he needs 2 months. Made a video about that. Okay. And this right here is pretty much the government's response to that. This was filed, I believe, yesterday as well. Says the government respectfully submits this letter in response to Diddy's sealed letter filed earlier today seeking materials in possession of a victim witness. The government's like, okay, that's cute. We're not in possession of it. The statute clearly says we're not in possession of this stuff. So I don't know why he's writing all these cranky letters. Now you're going to see this is a theme. This is a theme with more than one piece of evidence, which is at issue here in the trial that the government does. They claim they don't have possession of it. But the statute does say, and they keep arguing about it back and forth. I mean, there's a lot of pages going on. The statute does say documents in the government's possession or under their control. Okay, in their possession or under their control. And so the feds are saying these documents are clearly not under our control. So we don't, because, we don't possess them. But, if you're a criminal defendant, you might be going, you can control it. If you give them a subpoena under the criminal, subpoena power, you have control over whether or not you want to subpoena those records, and you need them, and I need them. So the only reason you're not, Diddy's side is arguing, is because you don't want to turn them over. And again, like I said, this is arguments that are being applied to more than one piece of evidence. Okay. Right here, we're talking about adjournment, but why? Remember why, the underlying foundation upon which why that Diddy wants to have an adjournment, or he's threatening to need one. One is because there's supposedly some substantially new charges in this superseding indictment about the forced labor and about the trafficking, or, whatever, the forced trafficking of victim 2. The other reason he's saying he needs 2 months is to adequately prepare and resolve the issue of victim 4, the WhatsApp messages, the ones we just talked about in the previous document. So, reading something else, comments. So, the government, this is the feds, this Maureen Comey, James Comey's daughter or niece or something. She's saying, no need to have us get that in our possession or control. We don't have to do that. We're not required to do that. We're not supposed to do that. And Diddy just needs to get over it. That's not in our possession. That's not in our control. Brady also only extends to stuff that's within our control. So moving along. All right. So then next we have document number 233, Diddy's motion to the adjournment. So previously Diddy had hinted that he might need a 2-week adjournment. He had said it at the arraignment on Monday. Well, the judge gave him, I made a video about this already, but at the arraignment on Monday, the judge gave Diddy 48 hours to file a motion. He said, I'll give you a 48-hour. If you're going to file a motion to adjourn, to extend, to push off the start of this trial, you need to do it in the next 48 hours. The judge told that to Diddy and his side on Monday. So yesterday was the deadline, the 48-hour deadline. And so they did meet it. And this is the filing we're looking at here, 233. Diddy said he needs more time to prepare his defense because there's substantial new charges. I just discussed that. They talked about there being a 15-year minimum sentence on this substantial new charge. And so the fact that the stakes are so high, they're saying we just need a little more time. Also, they want to resolve that issue with the victim 4 evidence, which is that WhatsApp situation. Maybe it's KK, maybe it's not. I really don't know. And then in this letter, Mark Agnifilo says to the judge, he kind of tattles a little bit, a little tattletale-y. He says, Your Honor, the government, the feds are telling me that they're not going to produce the evidence, even though they owe it today, until this whole when is the trial starting issue is resolved. But they have a duty to give it over today. And the things that were due today, this is filed yesterday, were exhibits, a witness list, and so-called, quote, 3,500 materials. And the relief sought in here is no longer, again, I made a video about this yesterday, but he no longer wants 2 weeks. He wants 2 months, Agnifilo said. Okay, so then the next document is Brian Steele. This is young, truly humble under God's lawyer. Amen. There we go. We have a young thug, aka truly humble under God. If you remember, he had a pretty memorable lawyer in his longest criminal trial in the history of ever. I mean, is that thing still going on? He's going to trial again? Oh my God, my nose itches. So at docket number 228, Brian Steele, Young Thug's lawyer, he had tried to join Diddy's case. Now, there was a little bit of a filing error. He didn't submit a certain thing with his name on it as an affidavit, so he got a little bounce back note from the clerk. So then again, that was 228, docket 228. So then at docket 234, he finally gets around, he butts his document in the midst of all these other filings to file his appearance. Now, you will see this later, but this appearance has been accepted. So you heard it here first. Probably not first, but as of today, Young Thug's lawyer has been officially added to the defense team in the Diddy trial. There'll be a slide dedicated to it at the appropriate time. Okay, so then we get an order at 2:35. Now, this was confusing because even I myself last night, I saw the word granted, and I thought that meant that a 2-month adjournment was granted. And I did think that that was a little bit rushed. I felt that was a little bit rushed. I felt that was a little bit rash. I think my lights are doing that because of my fan. Okay, hold on. So it was not actually granted just yet. This is the relevant part from that order. This is the judge's order, docket 235, pending this Friday's conference, and that's going to be tomorrow. The parties, this is the judge's order. The parties should proceed on the current schedule, including making all required disclosures. Okay, so the first sentence here is the judge saying, government, let's not get carried away. I haven't pushed anything back. You still need to turn over everything due today. We need to keep it moving along. Okay, so remember in Agnifalo's letter at the earlier docket point, he was kind of tattletaling on the feds. Well, this is the judge saying, no, y'all can't do that. Give him over the stuff that's due. Second sentence, as for the evidentiary issue pertaining to victim 4, this is the WhatsApp messages, which was first brought to the court's attention on Monday. So this is, the day before yesterday at the time he's writing this. The court will address that issue at Friday's conference. Okay, so the judge is telling us right here, second sentence, that as far as the WhatsApp messages are concerned and whether or not that needs to be put, an issue to push off 2 months of trial for, remember what the judge is writing on in this blue ink, this blue, font right here. He's writing on the request, on Diddy and Agnifalo's request for a 2-month extension. So last night, we're thinking it was already granted on like 5 minutes after he asked for it, but it wasn't. What was granted was a hearing on the matter. The judge is going to take it under advisement. Look, he says, if Combs has a renewed application for that evidence that addresses some or all of the government's objections, the court will promptly consider it. Okay, so the judge is saying, I'm going to handle this tomorrow. It was like the day after tomorrow at the time he wrote it, but at the time we're doing this live, tomorrow. So this will get handled tomorrow, this whole thing about victim 4 and the WhatsApp messages and the screenshots, and does the government have to have it in their control? And the government is also saying that victim 4 don't even have the messages anymore at all anyway, even if they wanted to subpoena it. But, Diddy's saying she might be lying or something. They should try to get the device, or I don't know. The judge saying, I'll handle that. In the meantime, y'all just keep going on like the clock is still ticking. Thank you. On top of that, Diddy, the government has now responded, objecting things, basically opposing you. So can you please also reply to what they've said? Because they have some arguments you have left undone. And the government, the judge did say in court on Monday at the arraignment, he said, I don't want to take anybody's word for anything. I want to take anybody's arguments for anything. I want to see case law and precedent. I want to see what authority I have to do this stuff. Okay. So next, Diddy motion. Okay. So the next document is 236. This one is just like a notice or something. So let's go to 237. It's related to the same thing. Now, this is a brand new piece of evidence that Diddy wants precluded, excluded, not included in his trial. Okay, brand new. We have several different kind of buckets of evidence floating around and several different specific pieces of evidence floating around that Diddy does not want in. So here we are meeting a new one. A new one is entering the chat at docket number 237 in the memo in support of the motion to preclude. Now, we talked about victim 4. That's the WhatsApp messages. We talked about victim 2. This is the one upon which Diddy is basing his argument that he needs more time to prepare. It's a 15-year sentence. Victim 2, ST. So now we're going to be talking about victim 3. This evidence pertains to victim 3 in the trial. Now, this was filed yesterday at 6 pages long, and so much of this one is redacted that it is difficult to figure out what is going on. For what I was able to find out and figure out, it's Diddy is basing his motion to exclude this evidence on a few different rules of evidence. Rule 401 is the relevance rule, and Diddy is saying it's not even relevant. What this victim 3, I don't know if it's testimony. I don't know. He also says that even if it is relevant, it's unfair. Prejudice would be, outweighing the benefit or the probative value. It would be unnecessarily cumulative. And he also says that it would cause an undue delay, a time delay in selecting the jury, because they would have to go through one by one and run the jurors through this one piece of evidence to make sure that they weren't going to be impartial. Now, Diddy's argument back is substantially redacted. This is the example of that. See how it's like just all blacked out? Okay. So I just can't exactly tell. I can only speculate what's behind those black bars. But there is something in there that refers to, quote, disagreements between SUL partners and redacted, and that is, quote, unremarkable. That is at page 2 of this document. And so Agnifilo, or I don't know if it's Shapiro, whoever, whichever one of Diddy's lawyers it is, there's an arguing that somehow this victim 3 relate the evidence that Diddy's trying to keep out in this, it's new evidence entering the chat. We've never heard this evidence before. This is the first time we've heard of it in this trial so far as the public. Victim 3 apparently was some type of SUL partner, and this had something to do with a disagreement between him and Diddy, she and Diddy, her and Diddy, and Mark Agnifilo, or whatever lawyer it was, said that this is, characterized it as a disagreement between SUL partners. So this is what the evidence must pertain to if, my speculation is right. Now, this document, again, 6 pages long, from Diddy's side, also says explicitly Diddy did not coerce victim 3 into doing any acts, and also that if you were to let this evidence in, it would unnecessarily outrage the jurors, and it would result in Diddy not getting a fair trial. And there's no reason to introduce this evidence, because the reason that, again, this is Diddy's arguments, but he's saying the reason that the government wants to introduce this at all whatsoever anyway is just to show coercion or control. And they have so much other evidence of that. There's no reason to put this in there. But again, it's hard to piece together the argument without being able to see it in full. Thank you so much, Robin, for the $5 super chat. I really appreciate that. Okay, let's move to the next one. That was document 237. Again, this is kind of just one example of exactly how redacted this particular filing is, and it has to do with victim 3, brand new evidence. Diddy wants excluded. When I say brand new, I mean to us. I mean to if you've been following the playlist on this channel. Okay, so the next document is document 238. This is a declaration of Diddy's lawyer, Teeny Garagos, in support of his motion to exclude that evidence about victim 3. Again, very, very redacted. Something maybe to do with a disagreement between SUL partners. That's unremarkable. The jury doesn't need to see it. They would be outraged. This is apparently also this declaration that Teeny filed did come along with a sealed exhibit. I can't see what it is, but she describes it as A3500 material for V3, victim 3 redacted. All right, the next document is a 239 notice of motion to exclude yet more evidence. Okay, now this one is the one having to do with the prior bad acts, the propensity purposes, memo and arguments on the next slide. Okay, let's see. Diddy motion to exclude. Is this the one with the nightclub? Yeah, okay. So this is like a one I thought we should pull up. So let me do that. This one talks about 2 other incidents, and I think this one might perhaps, again, it's redacted. I have no way to know. I'm not saying who celebrity B is, okay, but I think this one mentions J-Lo behind the redacted bars. I'll tell you why I think that. It's just an opinion. Don't say I started this rumor, Nancy Grace. I do think this has to do with J-Lo. I don't know, though. It's redacted, so let me pull it up. Docket 240. Okay. So here is that document. Diddy's motion eliminate to exclude Rule 404B evidence. Now, I made a video about this and I have notes and everything. Y'all should go watch that. It's about what is Rule 404B and what is Rule 404 evidence? This is evidence of prior bad acts, prior crimes, evidence that's offered up just for the sole purpose of making it look like the defendant has the propensity to do something like, oh, he was no good XYZ in the past, and now he is again. He committed this crime in the past, so he's committing it again. Okay, so this is Rule 404B evidence as other crimes, prior bad acts. Okay. So there's 2 new pieces of evidence entering the chat that Diddy wants to keep out. Alert, alert. 2 more new pieces of evidence. In addition to the one we just talked about, that's that victim be redacted. In addition to the other ones we talked about, that's that victim for WhatsApp messages. Okay, that's not that. This isn't the testimony of the prior SUL partners. We're not talking about that. This is new evidence just filed yesterday. Diddy is saying that the government wants to introduce evidence of a 2001 New York City nightclub incident involving a pew-pew, an incident upon which he has already been acquitted. I don't know. Is this the Shine nightclub shooting? Was he dating J-Lo at this time? Okay. This is the evidence is inadmissible, Diddy says, under Rule 404B2 because it's prior bad acts. Plus, he's already been acquitted on this. He would have to have a whole bunch of miniature trials, the propensity. Also, he says that the credibility, there's only one witness still alive that could be testifying against him, and the other one's dead. It's like dusty in here or something. Okay, so not only that 2001 incident, okay, but also the government, the feds apparently want to introduce testimony or evidence about this other alleged studio assault on an alleged studio executive. So I knew that y'all would just be eating this up. Y'all be loving it. So what is this studio assault? I'm not as, up on some of the lore as it were, but look. In its Rule 404B notice, the government wants to introduce something. This has nothing to do with the charged offenses against Diddy. That would be the relevance. Both should be excluded. This is the evidence about the nightclub incident and the studio incident, 1999 and 2001. Diddy says, or his lawyers say, those allegations were only supported by one single witness, whose testimony was convincingly refuted by substantial evidence at the earlier trial. So this has already been on trial. That trial lasted 7 weeks, Diddy's lawyers say, and included testimony by 60 witnesses, including a defense witness who is now unalive. As for the studio incident, the government has not even interviewed, redacted, and one witness, redacted, who knows what that says, but then Diddy's lawyers go on. In other words, it is unclear the government can even prove these decades old allegations even happened, much less it seems to be clear that they never happened. Also, the passage of time and other factors would prejudice Diddy's ability to disprove the allegations. But even if the incidents actually did happen, Diddy says, they would have no relevance other than propensity. And whatever minimum value they might have had would be substantially outweighed by the danger of an unfair trial, Diddy is saying. Okay. In a 2001 state criminal trial, Diddy and his then bodyguard Anthony Wolf Jones faced charges arising out of a 1999 shooting at Club New York, a midtown nightclub. Combs was charged with several pew-pew crimes as well as bribery. Okay, he was charged with bribery as well. After a 2-month trial at which both he and Jones, his bodyguard, testified, they were both acquitted on all counts. Jones has since become unalive. Diddy was acquitted on a charge so the government, they're saying that the government wants to submit evidence from this, maybe testimony, I don't know, as so-called other acts evidence, to argue that Diddy engaged in a pattern of obstruction throughout his life. Okay, so this is like teetering on like, you're not allowed to introduce this. Remember, you're not allowed to introduce evidence, propensity evidence, for the sole purpose of showing that Diddy had a tendency to act a certain way. And if they are introducing it to try to show, quote, a pattern, how is that not propensity evidence? I mean, I don't know. Diddy's lawyers say based on the 3,500 materials, it appears the government intends to rely solely on testimony. So we're not going to be looking at tapes. We're not going to be looking at receipts, invoices. We're just going to be hearing testimony. The government interviewed redacted, who testified. So someone who testified for the defense in the 2001 trial. Okay. So who testified for Diddy's defense in the 2001 trial? Is it Jennifer Lopez? I don't know. I want to know because they said over 60 witnesses testified. So that could just be anybody. Who testified for the defense in the 2001 trial? But it would be somebody who testified for Diddy. The government redacted, who was present for the alleged incident. The only other witness present, Jones, is no longer alive. Okay, so 2001 trial for the 1999 pew pew at Club New York. So was that the J-Lo thing? Because they say down here, the only, and I need to put a question mark here. Look at this. Only other witness present, Jones, is dead. So who is this redacted that was interviewed? That's my question. Who is a witness for the defense who might have been interviewed? The government seeks to prove that after the shooting, redacted, blah, blah, blah. This is the same basic story redacted told at the 2001 trial. But his story, okay, well, guess that ain't J-Lo. His story quickly fell apart. I guess that wouldn't be J-Lo. Which is why Combs was acquitted of the bribery charge. New York police booked both Combs and who in custody after the shooting. Who got booked along with Diddy? Look, quote, New York police booked both Combs and redacted. I put J-Lo question mark. I don't know. I thought I remembered that in the back of my memory bank somewhere. It was J-Lo. People are saying J-Lo. Yeah, the Shine. It was a 1999 pew pew. Shine might be the redaction. Inanna's girl is saying, okay. Maybe it's not her. Jones could be Anthony Jones, but why would it be redacted? Because they didn't redact Anthony Jones in any other space. Look. Jones, they say his name. Only other witness, Jones, is dead. Government seeks to prove that after the shooting, this same basic testimony somebody told at the 2001 trial. And whoever it was is a man, and his story quickly fell apart. So I guess this is somebody that would be testifying against Diddy. Because if his story quickly fell apart, and for that reason Diddy was acquitted, that means his story was against Diddy. You see what I'm saying? If not, rewind it, slow it down, and listen until it makes sense. Okay. New York police booked both Combs and somebody redacted. Could be Shine. I don't know why it would be redacted, maybe. Into custody after the pew pew and after taking a property inventory that included anything valuable. They did not record any diamond ring. Okay, so that's a little piece of evidence right there, right? What's this diamond ring? The New York Police Department officer responsible for booking any property that evening testified at trial that if there was anything valuable in Diddy's possession, he certainly would have booked it. Okay, so there was a diamond ring. I guess Diddy bribed the cops with the diamond ring is the allegation, and they're saying the cop is saying no, he would have saw a ring. At the 2001 trial, he testified the offer was made too many to remember, anywhere from a dozen to a couple dozen. It was something that was repeatedly, constantly, verbal assault, verbal barrage. The offer was made too many to remember. It's too much redacted. I don't know what this is, what it says. But Diddy's lawyers are saying the story is not credible. The evidence is inadmissible anyway under Rule 404B2, the bad acts, the prior bad acts. This evidence is required to be excluded. You cannot include this evidence. The 2001 bribery acquittal demonstrated that redacted story was highly questionable, especially given that the supposed diamond ring that was offered did not even exist. So this diamond ring comes into play with the alleged bribery allegation, prior bad acts. And so Agnifilo or Shapiro, whoever it is, Diddy's lawyer, is saying, we're going to have a whole entire miniature trial on this diamond ring crap. Okay. This is not something that has been previously proven. And it's also been like 40 years or whatever, like 30, 20, however long ago 2000 was, what is time. And, 25 years ago. So you just can't include this, Your Honor. Yeah. The alleged acts are not similar. And even if you could let this in, it's going to be unfairly prejudicial anyway. We would need to have a bunch of little mini trials, okay? That would involve among other things, an exploration of Redacted's credibility, including his invention of the invisible ring. Okay, so who is this Redacted? It's somebody who invented an invisible ring. This diamond ring having to do with bribery. The testimony the government produced includes testimony of Anthony Wolf Jones, who testified at the original trial and was acquitted, but he has since died. The primary other living witness would be who? From the 1999. Who was there that night? Who's the primary other living witness? J-Lo came to my mind, but obviously it's a black bar. Who knows who it is? In sum, the probative value of the evidence, Diddy says, it just doesn't outweigh. And look, the studio assault. So that first thing, that was a 1999 supposed shooting. This is something about a studio executive. The alleged 1999 assault of a studio executive, it should be also excluded for similar reasons to the exclusion of the club at New York incident. Okay, so what is this? What is this studio executive? And the first person that comes to my mind is Kurt Burrows, but I think that would have happened earlier, right? Like 1993 or 4. So who is the 1999 supposed assault of a studio executive? Again, this is the 1999, same year. 1999 club incident at Club New York, and then now this is a 1999 assault of a studio executive. Let me see if y'all have said Steve Stout, y'all are saying. Natanya Rubin is the lady who has come out. She suffered a blows to the face. Yeah. A common thread, Diddy's lawyers say, running through the government's trial strategy is to argue that Mr. Combs has been a criminal his whole life and is a bad person. The government has defined racketeering offenses very broadly to include his entire personal and professional life spanning 2 decades. On top of the charges, the government now seeks to admit numerous uncharged alleged acts of sexual misconduct and supposed violence. Every bad thing Combs has ever supposedly done in his entire adult life. In so doing, the government has not even purported to comply with the Rule 404 by demonstrating with any care what legitimate chain of inferences these acts support. The strategy is transparent, Diddy's lawyers say. That is why there is a rule forbidding this type of evidence. Okay, so that I thought y'all would find is interesting. I don't know who it is behind all those redacteds, who's the primary other living witness. I would love to hear theories in the live chat. But in the meantime, let's move right along to the next document on the, oops, not that. To the next document on the PowerPoint. Where were we? No. Is this how it was? No, I don't remember. I guess this is okay. No, this is how it was. Okay. Okay, let's see. We were here. Did 240. Okay. So 241 is Teeny Garagos's declaration in support of what we just read. That was the incident with the 1999 club incident, and also that upon which Diddy was convicted and not convicted, upon which Diddy was acquitted, for which Diddy was acquitted, not convicted, he was acquitted. And also this 1999 supposed alleged incident having to do with a studio, some type of studio executive. Again, the government does tease, and I do want to point out too that the reason Harvey Weinstein's his conviction was overturned, it was in the state court, but it was overturned on federal constitutional grounds, 14th Amendment, they didn't say Fifth Amendment because it attaches on the states through. I think they are using like the New York Constitution, but all of the state constitutions are modeled after the federal constitution. And so I predict that this is a new wave of legal arguments which are going to be being argued continuously, persistently. And I think it's a good reason that they are. I think it's for a good reason that they are, because I do think that it is constitutionally sound arguments. That being said, I see the government and the feds in this Southern District of New York case going down the same path that led the Harvey Weinstein state prosecutors to have their conviction overturned. And that is introducing testimony of people who allege that they had a previous encounter of an sexual nature with a defendant. And this previous encounter is not being charged by the government. These acts have never been charged. They haven't been found guilty. It's just like letting anybody come up there and sit and say whatever they want, basically. And this is what's being introduced here. So I just want to flag that as, something that could happen. Thanks so much for the 199, Empowered Wendy. Thanks for your hard work and being you. Thank you so much. Robin, welcome to membership. Shout out to you. Okay, so let's move to the next document. That was just a declaration in support. All right, so then we have document number 242 through 243. This is a motion for hearing on that CNN hotel footage, okay? Now, this is tedious. This was filed today. Agnifilo wants a hearing. He's asked for this before on the bail consideration motions. He's asking again. He has this forensic video expert named Connor McCourt. And Connor has done a very meticulous and tedious analysis of the Diddy hotel footage. Now, not only do they have the footage from the CNN copy of that footage, but they also have some iPhone footage, which is like a video iPhone recording, iPhone 6, video iPhone recording of security footage. Diddy doesn't think any of it can come in, and he's argued to keep it all out. And I do think it is a very clever argument one of his lawyers makes. I don't always give Agnifilo the credit, but one of them, I don't know who it is, says, if a picture is worth 1,000 words, then a video is worth far more many words than the court's page limit or their word limit. And it's like, okay, that's actually, you know, a nice little rhetorical device. Videos are irreparable. So their argument, Diddy's argument is the videos are so irreparably manipulated, there's no way to rescue them. Some of them are sped up, some of them are slowed down. Some of them, Diddy legitimately argues it makes them look too wide. The aspect ratio makes him look too wide, and it makes him look more domineering. Some of Diddy's arguments I find to be a little stronger than other ones. Some of his arguments I find to be a little weaker than other ones. But it does just remind me of that 2007, the takedown of Britney Spears. It's one of the ways they took her down. You know, they were dragging her in the media, and one of the ways they were doing it is that they were body, you know, shaming what she looked like. And it was right 2007, right around the time when we were shifting over from our square TVs to the more widescreen aspect ratio, and they shot the videos in square screen and she looks, you know, snatched or whatever. But then when they spread them out to the wide angle, the widescreen aspect ratio, it spread her out. Now, guess who she was hanging out with just one night before? The night before. She probably was the reason she got drunk and everything else the night before and all had to be carried out the club the night before in Vegas. It was Diddy. She was with Diddy. She was with Diddy. So now, you know, 2025, we have the widescreen. Yeah. I mean, no, I'm not saying Diddy's the one who did that. Okay. But I have a video about it. So I could link it. BJ Investigates. It's on the in any event, I think it's on the Stonebridge playlist. And this ties Lou Taylor back in as well, because Lou Taylor was trying to be Britney Spears's business manager at the time. Britney Spears did not want her to be her manager. She said, I'm scared of this lady. She's a stalker. And she emailed her lawyer, Britney did, and said, if I die, who's going to pay your bills? So, anyway, moving right along, let's see. Also, what else? They don't know who edited it. See, okay, this is egregious to me. CNN allegedly. Now, Mark Agnifilo has been known to give a false or a not true statement to the court before. Like, you know, that time that he said that the notebook said legal notes on it, even though it didn't at a certain time or whatever. So take his word with a grain of salt. But if what he is saying is true, it's egregious. He's saying that CNN received the footage because they paid for it. They paid a source for the footage. They paid for it, Diddy's lawyers are saying, and they recopied the footage into a different free online video editor called clipchamp.com. And in so doing, it transcoded the file type, meaning it took it from like a MP4 to a .vid file or something. I don't know, whatever it was. But like, you know, the dot ding, ding, ding at the end changed. So in so doing, all the metadata of the original video was lost on both the original CNN footage. I'm saying CNN, but the original surveillance footage and also the iPhone recording of it. So Diddy's lawyer attaches emails to the back of one of these filings showing that CNN's lawyers, their law firm, CNN's hired a law firm, very prestigious law firm, Davis Wright Tremaine, and this law firm has seemingly confirmed that CNN did delete the footage. So they paid for footage from a source, according to the allegations in this Diddy's allegations. CNN paid for the footage, converted the file type on a free online video type thing, also sped up, slowed down the frame rate. It messed up the metadata, can't tell who and where it came from originally, can't authenticate it. And so for all those reasons, you just can't know. The timestamps are messed up, they saying. Don't know who edited it. Don't know who received it. Can't tell you which employee was the one ran it through the clip champ. Can't tell you which employee deleted it. So they just don't have any information. Okay. So the government in docket 244 finally does respond back to Diddy's to Diddy's motion for that adjournment. So Diddy's saying he needed 2 months more. The government said he is doing nothing but being a gamesman. He's doing gamesmanship. There's not any substantial new charges, and there's not that much new evidence, not that much new data for him to go through. There's like a few hundred more pictures and videos. Also, we've been calling victim 2 an ST victim since at least January. So he's been on notice. It's not substantial new charges, 15-year minimum or not. Now this is the government's finally responding back to the judgment. The judge told them, look, y'all still got to turn stuff over, even if we do adjournment or not. We got a deadline and you got to turn stuff over. The due date was yesterday. You got to turn it up. You got to turn it over. The government here is saying, okay, yes, sir, Your Honor, we'll do that. But if you grant the adjournment, we're going to do a clawback. We're going to claw back all the evidence we gave because we don't want Diddy to have it for that long. Now, is that going to be successful or not? I could not tell you. I do not know. Okay. So, they also reiterate that they don't need an adjournment anyway. Because the reason that Diddy's asking for this adjournment has to do with this victim 4 evidence. And we already told Your Honor, we don't have that. We don't have those text messages. We're not going to request the text messages from the WhatsApp. We're not using them at trial. We're not using them against Diddy. The only thing we're using is 3 screenshots. He has the 3 screenshots. Why are we supposed to go in and ask for every single WhatsApp message that ever existed? And Diddy's like, yeah, you are. So that's what's going on here. That the argument, the government saying it's not in our possession. Diddy's saying, well, you should get it in your possession with a subpoena. Okay, and then at 245, we have declaration of Diddy's lawyer, Anna Estevallo, regarding that footage. She includes a lot of exhibits. Some of them are sealed. Some of them are not sealed, but they are still redacted, with the black bars. And then some of them are not sealed at all. And this does include the email with Davis Wright Tremaine, which is CNN's law firm, saying, yeah, CNN deleted the original. We don't have the original. Sorry. That's crazy. And Diddy's lawyers do make some strong arguments. Like CNN itself reported in headlines and news articles that footage was likely to be used at trial and they deleted it. I think that's a pretty strong argument. I'm sorry. Okay. Then document number 246, we get the affidavit or the declaration from that forensic video expert, Connor McCourt. Now, I'm a little bit confused, concerned. I don't know, intrigued, I'll say, by this guy's resume because he's worked as a TV producer and a director. He's done 3 documentaries for HBO, same when it was with Cinemax. And then he's also worked, before he was a cop, an NYPD cop, he worked on America's Most Wanted as a TV producer, but he does give a very meticulous analysis. He's like down in the timestamps, y'all can go read that. It's document number 246. This is where he says Diddy looks like, they got him on the wide angle, fat cam or whatever. Can't use either one, the CNN footage or the iPhone footage, because the timestamps, the bias. Because remember, the judge had said, okay, so the footage is sped up, so slow it down. And this is them trying to say, like, please just give us a hearing so we can show you how that's not just that simple. And it may be, but this is them, saying they want a hearing. Okay, so then at docket 247, this is filed also today, just one page, about 1:30 p.m. we have Brian Steele is allowed to come on as Diddy's lawyer. He will be joining Mark Agnifilo, Alexandra Shapiro, and the rest of the gang. Okay, is there anything else? Okay, so that's the end of this actual slide show, but we do have several more documents. So let me pull up the docket now. Watch, there's gonna be new stuff. One, two, three, four, 5 new things since last time I got on here. Now it's like 30 documents. We're up to almost 30. It's 27 or 28. Okay, let me pull it up. I got it up. Let me share it. Okay. So what we just did was 247. That was the order granting Brian a Steele admission to the case to defend Diddy. He's on Diddy's team now. 248 is the response. Okay. So 248, the government, the feds had filed to protect the victims' names from the public, okay, to keep them secret forever. Never let us see who these victims and these witnesses are. Diddy has filed an opposition to that. I have not had a chance to read it yet, but that is what was filed there. He's, presumably he's arguing on the behalf of the public, saying that we have the right to see certain things. 249, affirmation of Diddy's lawyer in support of that document about the protecting the identities of the victim witnesses. 250 is a letter addressed to the judge, response to a motion. Okay, so this is another letter. Okay, so 248, 249, and 250 all have to do with the victim identities, keeping them private, keeping them pseudonyms, etc., etc. 251 and 252 have to do with the, oh my God, Wigdor. Breaking news. Douglas Wigdor has filed in this case. Breaking news. This is Cassie's lawyer. Remember the one that Cassie's lawyer? Oh my gosh. Okay, hold on. I got to open that document. What is it? A subpoena. Oh my God. Okay, y'all, hold on. Just give me a second. This is live. Oh, it's a motion to quash by Douglas Wigdor. Welcome. There's more than 1,000 in the chat. It's one page only. Whoa, hold on, y'all. This is Cassie's lawyer. It's breaking news. Cassie's lawyer filing in the Diddy criminal case today. Since I started this video, I think. Let me put it in my system here. Hold on. I got to categorize these things, y'all. You see there's like 30 in a day. It's going to be doing like this coming up to trial. So this breaking news, this is Cassie's lawyer filing the same thing that the Warner Brothers company, the Warner Brothers Discovery, has filed. This is the motion to quash. This is breaking news. Cassie's lawyer has filed a motion to quash. It's one page long. Let me pull it up right now. Okay, here we go. Okay. Look at it. It's not very long, is it? Please take notice. We're moving to quash the non-party subpoena served by Diddy. So when did they put it up yet? The memo? Okay, is that one of the things up? Okay, let me see. Hold on. Oh, y'all, we gotta see what Douglas Wigdor is saying. Memorandum in opposition. Yes. Okay, here we go. So it's going to be at. Oh, somebody else. Who else? Oh my God. So many new things, y'all. There's another new thing. Oh my God. Okay, y'all. This is like literally this. You're getting the. You are getting the behind the scenes. This is what I'm doing all day. I'm like, oh my God, just as soon as I was about to go to make a video, they got 7 more things just got filed. Are you serious? So I'm pulling up right now. If you're just joining, hello, hit the like, breaking news. Cassie's lawyer has filed a motion to quash Diddy's subpoena in this case. I was just going over like 20 something filings, that have just happened since yesterday in the case. So I was like, oh, before I get off the live, let me go check and see if anything new has been filed. And I kind of figured it would. And it was 5 new things. And one of the new things was this Cassie, her lawyer, Douglas Wigdor, has filed a motion to quash the subpoena, does not want to give over evidence. Diddy has asked Cassie for evidence, and her lawyer has said no. And we're opening the document right now, 10 pages long, of why. What are Cassie's reasons that she's giving through her lawyer, Douglas Wigdor? Here it is right here. Wow. Wow, 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 indeed. Okay, here we go. So I need to... Wouldn't mind me giving Inner City a shout out. Yeah, you should give him a shout out. Okay, so here's the memo. Cassie, non-party, I'm assuming Cassie, buying through her undersigned counsel, files this motion to quash in connection with the subpoena that was served by Diddy on her on March 19th. So this was about a month ago that she got the subpoena. And also, y'all, this could, oh, here we go, y'all. Diaries. Oh my gosh. Yep. He's not asking for the memoirs and the diaries from the documentary company anymore. He's asking from, I'm assuming this is Cassie. I don't know for sure because Douglas Wigdor could be representing any number of people, but the subpoena demanded that somebody produce all draft memoirs, autobiographies, narratives, diaries, journals, or notes, and any communication about them, the plans to publish, threats to publish, and all of her bank statements. They want all of her bank statements? Okay, chill out. In this case, I'm going to say this is Cassie, but I don't know. The lawyer says Diddy cannot demonstrate the admissibility of these documents, nor can he meet the bar of specificity required under law. You can't just request somebody's diaries, Diddy. They go through the legal standard. This is a heavy burden. His requests, first of all, are not specific. He's requesting her bank statements for a sweeping period of 10 months in 2023. When counsel, quote, merely hopes something useful will turn up, the requirement of specificity to enforce the subpoena has not been met. So Diddy can't just be like, oh, I bet you there's something useful in the diary. The gathering specifically identified, they're trying to get a hold of people's diaries, okay? Because they were trying to get them from HBO, but they dropped that request. And now they're trying to get them from whoever this person is. The the request is too sweeping. A criminal subpoena that seeks a private document to evince some nebulous financial wrongdoing is inappropriate. Diddy has failed to even show that the documents he seeks are even admissible. In short, his request does not reasonably specify the information that he's actually looking for. He cannot just, get this diaries and money information. It is pretty private information, like diaries, journals, autobiographies, and all of your bank account information because somebody else is being tried in a criminal trial. No. Yeah, the request is also premature, they say. Wait, hold on. Does not become relevant until the witness testifies. Okay. So you can't request stuff until witnesses actually testify, is what Douglas Wigdor is saying. Finally, should the court order that she has to produce any of these documents set out in the subpoena, specifically, the banking documents, I would request that this be limited to opening and closing balances for any given month, as there's no conceivable basis for the production of documents that show every financial interaction that this person took part in over a 10-month period. Number two, I would like to have it limited to make sure that any production of this type is limited from disclosure. The documents that Diddy wants are private and financial documents. They will contain sensitive personal identifying information. And so for that reason, the client respectfully requests that such production be made pursuant to the protective order in this case. She or he wants it to be private. Okay, so let's see what else has been filed. Oh my gosh. I went on there and it had been 5 new files. Letter response in support of the motion by Diddy. Okay, let me pull this up. We're almost done, y'all. Relatively. Okay. Oh, go away. Go away. Okay. On behalf of Sean Combs, this is a 3-page letter. The defense submits this letter in advance of tomorrow's conference in further support of this motion to exclude the government's testimony. They want to provide this testimony from these alleged victims who were victims beforehand and the uncharged. These are the kind of like Weinstein type victims. The ones like these are not acts that are being charged here. At the April 14th conference, Diddy's lawyer said, the government misled the court as to the timing of its interviews with the 4 additional alleged victims described in the March 10th and 26th Enterprise Letter addenda. The defense writes to correct the record. So, Your Honor, the government lied to you. As the defense noted in its reply brief, it is clear from the 3500 material that the government has known about these alleged victims for months and months. In some cases, over a year. At the April 14th conference, the government stated that at the time its Enterprise Letter was due on February 1st, last 2 months ago, it was not prepared to say that this evidence would be part of its direct case in proving the racketeering enterprise and conspiracy. It further represented that it was aware of at least some of the alleged victims, but it didn't know how deep it had gone in its interviews with these particular victims. As an example, the government cited alleged victim 5, stating the 3500 material would reveal that the particular victim was interviewed multiple times in 2025. I believe much closer to the date of the revision of our Enterprise Letter. The government's representations were false, Diddy's lawyer says. The 3500 materials make clear that the government, redacted, intentionally chose not to include these individuals. And so the government's been hiding these people. Only changed its position after realizing the weakness of their prior 413, 404B arguments. We take each alleged victim in turn. Victim 5, the 3500 material reveals that nothing has changed since January 31st. The government's contrary representations to the court were false. Okay, it's all redacted. Oh my God, y'all. We got 7 victims. Breaking news. Minor victim 2. We have minor victims named. Breaking news, minor victim. Thus, nothing has changed since January 31st. The government contrary misrepresentation of the court were false. Minor victim 2. What does that mean? Victim 7, there's 7. Victim 6. The government was clearly in a position to include every one of those 4 alleged victims. These are the 4 alleged victims. These are the 4 alleged victims. Minor victim 2, victim 7, and victim 6. And victim 5. Victim 5, 6, 7. And minor victim 2, that means there's a minor victim 1. What does it mean, minor? Like minor and major or minor and adult? I'm curious. The government was clearly in position to include every one of these 4 alleged victims. In its case, 7 victims, yep, and one's called minor victim 2. 4 victims are supposed to be the alleged Molyneux 413 prior sexual assault things. The reason it failed to do so, the reason it didn't include these people in its letter beforehand, had it truly believed the evidence was relevant, it didn't believe this was relevant. The reason it failed to do so was not because it was not prepared to say that this evidence would be part of its direct case, but rather because of pure gamesmanship. Now, that's interesting because the government just accused Diddy of pure gamesmanship like earlier today or yesterday. And so now they're just accused they're Darvoing it right back. Pure gamesmanship the government's doing, Diddy says, and or its own decisions not to follow up with these witnesses. The defense should not be forced to defend against these late-breaking allegations on the eve of trial when the government is at fault. For these and additional reasons outlined, the court should exclude the evidence. Okay, so that was document number 255. Okay, let's go to 256. Woo! This is the second to last one. Oh my God, it's 20 pages long. Absolutely no way I'm reading this whole thing. Nope. Okay, here it is. Memo in opposition to motion to quash. I don't know who this is. Redacted seeks to shield important exculpatory. This must be Cassie. He's already responding to Cassie. Like, these things are already hitting the docket. Like, what? We just read her. It just came out. You just saw me break it. Seeks to shield important exculpatory information in her possession, and the government joins that request. In particular, she and the government seek to conceal copies of her draft memoirs and other writings that memorialize a version of events that is markedly different from what she has told the government, and that she will testify at trial. Okay, so this has to be one of Douglas Wigdor's clients. Now, is it Cassie? I don't know, because did Cassie interview on the fall of Diddy, the HBO Max documentary? Whose diaries were mentioned on that? Put it in the comments, because I don't have the live chat replay, so I can't come back and read them. Seeks to shield important exculpatory information in her possession. The government joins the request. In particular, she and the government seek to conceal copies of her draft memoirs and other writings that memorialize a version of events that's different from what she's told the government and different than what she's going to say at trial. Lines redacted. These relevant and admissible materials are crucial to Diddy's defense. They're precisely the types of documents that criminal defendants are entitled to subpoena from third parties. Depriving Diddy of such material would interfere with his Sixth Amendment right to present a meaningful defense and his Fifth Amendment right to due process. For these reasons, the court should deny the motions and order, I don't know who, maybe Cassie, to comply with the subpoena. A bunch of stuff redacted. On March 18th this year, about a month ago, Diddy made an ex parte application for a Rule 17 subpoena, seeking two categories of documents. Okay, one category is all the draft memoirs, autobiographies, narratives, diaries, journals, or notes, and any communication about her plans to publish or threats to publish such a document, and all bank statements. The court authorized the subpoena on March 19th, and the defense counsel, Diddy's lawyers, provided a copy to this person's counsel. I'm assuming it's Douglas Wigdor, and as you can see, a lot is redacted. At the outset, this person and the government argue that this court should apply the standard in Nixon, but there's no sound basis to do so. In Nixon, the grand jury investigating Watergate returned an indictment that named then President Nixon as an unindicted co-conspirator. The government subpoenaed the president, a non-party, who then moved to quash. The Supreme Court affirmed the denial of the president's motion, finding that the government subpoena cleared 3 hurdles. But Diddy's saying we shouldn't use the Nixon test. We should use this different test. Tucker. And the Tucker test is just that it would be helpful to Diddy. And Diddy is saying, even if you have to use the Nixon test still applies. The subpoena is not oppressive. I would disagree. Having somebody turn over their diaries Right to confront his accusers. Okay, so they didn't put a space here. That's okay. So, okay, interesting. And then let me get to the one last thing and then we will be done. Hopefully. Last document. $257. Okay, this is the declaration filed by Diddy's lawyer in support of what we just now read. I'm a partner, declaration based on my personal knowledge, exhibit A redacted, B redacted, C redacted, D redacted. Are you surprised? Womp womp. Okay, let me just refresh one more time to make sure that the let me make sure that like nothing else has been filed. I need to refresh. That's what I'm trying to say. Ooh, okay, hold on. Okay, one more thing that I do need to show y'all before you go is this right here. I don't know if you know this or not, but I do have a website and I do have some merch. Some of the sizes are already starting to sell out, but look how cute. Look at that. Slay. We got a size chart. We got a tank top just in time for the summer. All sizes still available. And we do have this beautiful They Lied bag. And when you're wearing your They Lied merch out in the world and people ask you, what's that about? You could say, go watch BJ Investigates or That Surprise Witness. Or you could maybe perhaps tell them about an instance where upon someone lied, any and every They Lied instance. Alice, you can email me at thatsurprisewitness@gmail.com. Also, if you are finding this helpful, interesting, stop it. ChatGPT referenced my video. You lying, Paige Collins. Thank you for $4.99 super chat. ChatGPT references your video when asked why Lou Taylor is connected to so many conservatorships. It says for a deeper exploration. And which video? Paige Collins, please comment in the comments, not the live chat, in the comments. I want to see the link. I want to know which video it linked. Thank you, Amber. Thank you so much for becoming a member. And usually I don't go on podcasts, but I have an open mind. You ordered the hoodie, Danielle, just in time for Easter sleigh. I do think it's Cassie is that one. Anyway, that's all I really had for today. I am absolutely wiped. I have been at this desk for 12 hours. If you found this to be helpful, I do have a legal fund linked in the description below. That is to protect my free speech rights, to keep doing this kind of work, to keep bringing this type of information to you. Also, you could donate at various other links here and there. But if you donate to the legal fund, that goes directly straight to lawyers. So that's all I really had for today. In the meantime, facts ain't defamation, neither are opinions. Love you, mean. Okay, bye.